All right, hey everybody, welcome back to Fiegel Files. This is Bo Fink, starting lawyer in Texas, here with a little different kind of podcast today. So I want to kind of give my feedback and reaction to a major news story in Bexar County. A local judge, Rosie Speedlin Gonzalez, was both charged with felony, unlawful restraint, official oppression, and then after that suspended from being a judge. And she's a candidate for that bench as well. Her second term is up and running for her third term. So I wanted to react, but more importantly, and right off the top, show my support for Judge Gonzalez. And not because I necessarily agree with everything that happened in the incident that has prompted this, but because I don't think she's being treated fairly, if I'm being completely candid. And I think that the motivations behind the fact that she's been arrested, the way she has been, and then the reactions online, the news coverage of her, and frankly, just the treatment of her, I think, has been inappropriate. I don't think criminal sanctions is the way to go. And I think what's really happening is this is somebody who's ruffled feathers and rubbed people the wrong way for some time. And rather than do the hard work, which is go win an election and beat her, they're trying to find a way to oust her through, charging her with what I think are inappropriate, trumped up charges, and kind of smearing her. So that's my opinion, and that's all it is. So I'm going to go to the incident, and then we're going to give some background. I'm going to go through the transcript somewhat briefly, go through the law, the applicable law, maybe dispel some myths, and just kind of give you my thoughts. I know it's easy to get clickbait, and I know some of my colleagues are making funny reels and memes about her, and you know what? They can do what they want. That's on to them. That's on them, and I'm not going to sit here and tell them how to manage their social media pages or how to conduct themselves. I personally will struggle to ever take joy in a colleague's misfortune, even if it was over their own making. I don't think this is completely of Judge Gonzalez's own making. I think this is somewhat targeted. But I think taking joy in people's misfortune and mocking them is something we should avoid there. I think that we should be very cautious, suspicious, and scared of police and DAs looking over judges' shoulders on when they're exercising judicial discretion. I'm not saying there's never a time to charge a judge with these kind of things. I don't think the time I don't think this incident prompted that in any way. I think it's a severe, not just overreaction, but inappropriate reaction and disproportionate reaction. And it's the wrong forum to discuss what happened on December 14th of 2020 or December 17th of 2024. So, as you probably read in the news, Judge Gonzalez was, let me get the news article up. She was arrested and charged with unlawful restraint by a judicial officer and official oppression. Okay, as been reported in a whole lot of local news, here we go. We have Bexar County judge indicted, accused of having an attorney handcuffed and kept in jury box. Judge Rosie Speedlin Gonzalez charged with official restraint by a judicial officer and official oppression. It goes through and it says what is true, that dispute arose between Speedlin Gonzalez and attorney Elizabeth Russell, escalated during a motion to revoke probation hearing. After the defendant pleaded true to one of the allegations, Russell cut in and asked for a moment to confer with client. A transcript of proceeding states. This is where I'm starting a little frustrated. The defendant functions below average intellectually, a source familiar with the incident told KSAT. After the incident, Russell filed a criminal complaint against Speedlin Gonzalez, 60. Thursday's indictment accuses Speedlin Gonzalez of restricting Russell's movements without her consent and interfering substantially with her liberty. Bexar County DA Joe Gonzalez recused himself. Of course he did. Brian Cromeans, district attorney for the 24th Judicial District, which includes DeWitt and Goliad counties, was assigned a special prosecutor. Record show. What happened, and let's just go ahead and switch to the transcript, is on December 17th, and I know Elizabeth Russell, there was a motion to revoke probation hearing for the criminal defendant. And so in motion to revoke probation, what happens is, and it's unclear from the transcript because they say both. They say that it's a motion to revoke suspended commitment and adjudicate guilt, but then they also say to revoke community supervision. So I don't know if the guy's on deferred or convicted. It makes some difference, but it doesn't make a difference for what we're talking about today. So here's the transcript. So 17/2024. I'm going to go through what happened, and then I'm going to want to dispel some myths because I think even the way that article framed it is problematic. goes through the court personnel, all that, whatever, right? Okay. They get on the record, give the case number. Mr. Brian Keith Collins, he's the gentleman that's facing revocation of his probation. What that means is when you're put on probation, you're given a jail sentence. Most of the time, it's in a misdemeanor. It's 6 months for a Class B, 1 year for a Class A. Usually, they just give the full sentence as the underlying sentence, and then that is usually probated for a period of time. Misdemeanors, the max is 2 years. I think for this one, he was probated for 12 months, but whatever. So they get on the record. The judge, reads who's in the courtroom, get announcements, and then usually you announce ready, not ready. Ms. Russell correctly said we have a preliminary matter. The judge allows that to continue, and Ms. Russell advises the court that apparently they attempted to file an amended motion to revoke, meaning they added a different allegation that he violated his probation and didn't properly serve her. So she correctly objected to that because she's a very good attorney, a friend of mine. And again, nothing I'm going to say today, just because I don't agree with the criminal charges being pressed against Judge Gonzalez means I have any problem with Miss Russell. I have any disagreement with her or any personal animus. I like her sincerely. She's always been very nice to me, and that's not going to change. So the state just waived that condition, and then they proceeded with the hearing. So Judge Gonzalez, who's referred to as the court, because that's how that's referred to, tells the defendant, you apply to be on community supervision as opposed to spending time in jail for the offense you're charged with, assault, bodily injury to a household member. Kind of freeze frame here. Judge Gonzalez is the judge of County Court 13, which is a misdemeanor court. So County Court 13, there's 15 county courts in Bexar County, 2 of which are exclusively civil. The other 13 are 4 of which do handle some civil, but basically 13 of the other courts are exclusively criminal that handle misdemeanor offenses. County Court 7 and 13 exclusively handle offenses dealing with family violence, usually assault, family violence, or terroristic threat that involves family violence, and that's it. I don't like this. I personally think that it creates a lot of problems. I understand the argument to the other side. It's not really why we're here today, but I do struggle with the idea of these alleged specialty courts because I think it breeds cynicism. I think it creates bureaucracy that doesn't need to be created, and I think it makes an unfair advantage for the state. That's a longer conversation and one I haven't researched near as well, so I'll be careful before I go too far, but I don't care for it. But Judge Gonzalez won this bench in 2018. She won it again in 2022, and she's running for it again here in 2026. Now, she's a long-time established attorney. She worked for CPS. She represented kids as a solo practitioner. She's handled domestic violence cases all over the place. She's a very accomplished attorney too. Unfortunately, some controversy on the bench I think has really marred and skewed the perspective on who this person actually is. I get along with her fine. I wouldn't call us friends, not in a malicious way. We just don't we never hung out together outside of the courtroom. I had a case against her, but prior to her getting elected, I've been in front of her a number of times. I don't know how many cases, but double digits for sure. I've always been treated fairly. I've never had a problem with the rulings. I've never had a jury trial in front of her, but I don't have a problem with her. And more than that, she's very accomplished. She's board certified in an area of family law. She's an expert in domestic violence, an expert in CPS, and has been on the bench for 8 years. And one of my things for today is if you don't like her, she reapplies for her job every 4 years. And if you don't like her, that's how you can get rid of her. But what you're not going to do is abuse the criminal justice system to get a result you want. I have a problem with that, as I think everyone here should. So she's in the court. This guy's charged with a misdemeanor. That's why the transcript's up. And she advises him that you were put on probation, and it looks like for a year, 12 months probation. And then she says deferred adjudication. I will explain the difference one day. It doesn't matter for today because it's the same issue. Now, when you are on probation and they file a motion to revoke probation and or to adjudicate guilt, it's for today's purposes, it's the same thing. When they read the allegation, you can plead true or not true. If you plead not true, the state has to prove it by a preponderance of the evidence that it's true. Then the judge has the authority and the jurisdiction to revoke your probation. If you plead true, the judge can revoke your probation right there, meaning take your probation away and put you in jail. Now, the difference between a plea of this kind versus a plea for the underlying offense, meaning if you haven't been convicted of anything or haven't taken a plea before, is The judge in an original plea cannot deviate from the terms of the original plea. Otherwise, you get to withdraw your plea and go to trial. So let's imagine in a felony, you plead to 10 years, you agree to 10 years, and a judge says, no, I don't agree to 10 years, I'm going to be 20. The judge can't do that. You can agree to the 20, or you can withdraw your plea. The fact that you pleaded can't have a bearing on the trial, and then you can go to trial. That's not true in these kind of proceedings. If you plead true, that alone, whether you have an agreement with the state or not, gives the judge the authority to revoke. So the distinction between true and not true is significant, and that's going to play a role here. So this guy allegedly didn't I'll go through why, but didn't follow his probation. Okay. The court reads the entire admonishment and says, my last question, do you understand the possible outcome of today's hearing? The defendant says yes. Okay, with that, will you proceed? And then he makes him swear. Okay, now pause, because the article says he's below average intelligence. Now, I don't know. I wasn't there. I haven't even asked Elizabeth this because I don't want to get her involved. I don't want her to have comments that she doesn't want. Again, I don't have a problem with her. I don't really have a problem with her seeking a criminal complaint. That is up to her. That's personal for her. If she made that choice and she feels like she needed to, more power to her. That's not my issue. My issue, though, is that I don't think it should have happened. Now, whether he's above intelligence or not, there was an entire proceeding before this when the guy pled where there's an opportunity to say that he was mentally incompetent, or here to say he was mentally incompetent. He's competent by law because they're having this proceeding. And again, what I will say about Elizabeth is she knows what she's doing. And if he was incompetent, she would have filed for that. She is a very hardworking attorney. So at some point, the court has to accept that he's competent and deal with it. And so this notion that he's below intelligence and Judge Rosie did something wrong here because of that, I think we need more context if we're going to report that in the news. All right. So the prosecutor reads again, and then he alleges 2 violations. One, that he didn't report for his probation, and 2, that he didn't do his community service. This is not uncommon. They withdraw any other, I don't know, I haven't seen the motion, it doesn't matter. They withdraw any other alleged violations. Okay. Here's the moment of truth. The judge says, Mr. Collins, I'm going to ask you whether the allegations by the state are true or not true. So that's all I need to respond right now. Your attorney will take care of vetting on any explanation you may have or calling other witnesses to make controvert, refute, or disprove the state's burden to prove you violated. There's literally, we're pinpoint perfect on the law right here. Now, notice in the article says, well, Ms. Russell asked to confer with her client. She said no. Well, they skipped this part because right after the judge tells him, Elizabeth says, Judge, can I have 2 minutes or 2 seconds to remind of our conversation? The judge says yes. Okay? So Elizabeth had all the time that she thought was appropriate because, again, she's a great attorney. She's not there if she doesn't think she's ready. And she goes up to do the plea, and she takes a step back on the record to remind this guy what to say. So here we get to the problem. Judge, my first question to you, Mr. Collins, is it true or not true that you failed to report to your supervising officer as directed and ordered by the court for the months of September, October for 2024? Is that true in violation of condition 4? Defendant, yes, ma'am, it's true. The judge, we have a true, and Elizabeth cuts in. Now, I don't know, but pretty obvious from the context, the dude was freaking supposed to say not true. Now, it goes off the rails right here. And I can read through the transcript and you can see it. But for the people that are mad at the judge, look, if you think she should have given more leeway, you can think she should have given more leeway. She's done nothing illegal. She's done nothing approaching illegal. Okay? The guy said true. The guy is competent by law to take a plea. He was competent again to go take a plea on his underlying sentence and on his revocation. He was admonished by the judge. He was asked, do you understand what's going on? He got a second chance to confer with his attorney to double check, and he fucked it up. I mean, I'm sorry. I mean, good. Do I think that maybe he should give him more? Maybe. If I was there, maybe I would say that, and maybe I would have preferred Judge Gonzalez. But this idea that she violated him here, dude, he's had 4 chances to say, I don't freaking understand. And he has a good attorney. So I can have all the sympathy in the world and have an opinion whether the judge should have given him more leeway to withdraw what he just said. But let's stop saying she did anything wrong, because it's by law not true. So that's one problem I have with the way this is being reported. So Miss Russell says she converts the client, and the judge goes, okay. And so Elizabeth says to Judge Mr. Collins would like to recall his plea of not of true and correct the record. And the judge goes, okay, this is what I'm going to do. Attorneys are not allowed to coach clients' answers to their clients. He was under oath. He stated true. That's what the court's going to recognize. You can make a record after he was told by his attorney to take the answer back and state not true. He stated not true. And then the next, she asked about the next one. He says not true. And then, okay, nothing, in my opinion, nothing's wrong yet at all. Here, this next sentence, I would have preferred be stated different by the judge. I still don't think she's violated anything. I think she's certainly not violated a criminal statute, and I don't even think any kind of ethics at all. But she goes, okay, so you state you have a true plea for violation of condition 4, and Mr. Collins then withdrew and stated not true after being coached by his attorney. I would prefer her said advised, because I think the idea of coached, I think that brought on and escalated here. Now, it's very clear by what happens next that there's a lot of history that we don't have access to. We don't know what happened. So we don't know. All we have is with the transcript and what people are saying. But here's what I'll say. But again, she hasn't broken the law yet, even close, the judge. Nothing. Because she's not wrong. That's what happened. Now, you can have an opinion of whether that's mean, of whether you think she shouldn't have said that. Okay. You're entitled to your opinion. But again, she's arrested and indicted for a felony and suspended for practicing. So let's freaking breathe before we get all self-righteous here. She hadn't broken the freaking law yet. Now, Elizabeth does nothing wrong here either. Judge, I'm going to object to that. The court, it's on the record. You can object all you want, Ms. Russell. And then Elizabeth says, I understand your position. Now, I don't know what the hell happened here, because now the judge is really mad. I don't know why. I think, and again, I don't mean this in any way negative to Judge Gonzalez, this is where the overreaction starts, and this is where I think this gets a little problematic. Judge goes, stop, it's on the record. Your argument of way is not going to work today. Stop, or hold you contempt, Ms. Russell. I will hold you contempt. Elizabeth, Your Honor, I'm allowed to speak. Judge, you are allowed to speak, but you're not allowed to be argumentative for the sake to argue and just for the sake of argument. Elizabeth, I'm not arguing for the sake. Judge, you are. Russell, argument. You're either going to hold your tongue or I'm going to hold you in contempt. Your Honor, make your record. I am acting professionally. You are not. This is why. You are not. I get to raise my voice in my court. I'm asking you for recusal. And the judge goes, take her into custody and put her in the box. We are not having this hearing this way. Ms. Russell, I'm arresting recusal. All right. And then we go on. And I don't know the time frame here because it's not set. I've heard it's an hour. She puts her in the box. The judge holds her in contempt. She lets her out an hour later. She recuses herself and it's over. That's what happened. Now, myth number 1. The judges can hold people in contempt in court, in direct contempt, immediately. Now, for those saying she's entitled to a notice and hearing, only if she motions for it, and then she's allowed to get on her own recognizance. That's the fucking law. That's the statute. Let me pull it up. So the case law on contempt is explicit. So the judges can hold you in what's called constructive contempt or direct contempt. Constructive contempt means I gave you an order and you were supposed to follow it. It's being alleged outside of my presence you didn't follow the order. I'm going to hold you in contempt. That can happen. With that, you need a notice of hearing. However, you are allowed to be held in direct contempt. So these are things like you're not answering the questions and you're acting inappropriately in court, and like you're flicking out the judge, or you're banging the table, you're pushing people around, you're ignoring like direct directives. The judge has every right to keep the proceedings going. She has an obligation to keep the proceedings going. And if someone's being that disruptive, that's why there's a bailiff, or one of the reasons there's a bailiff. You hold them in contempt right there, right then and there. If it happened in the judge's presence, they can hold you in contempt. Now, an officer of the court held in contempt shall, on proper motion, be released on recognizance, determination of guilt or innocence. That didn't happen here. Okay? It didn't happen here. So, I've got here, Ex parte Daniels. Let me share it. And that was Texas Government Code, I think, 2002. Let's go to the case law. Direct contempt is contempt which is committed or occurs in the presence of the court, such that the court has direct knowledge for the act's contempt. Constructive contempt. Let me go through. In cases of direct contempt where behavior constituting contempt has occurred in the presence of the court may conduct summary proceeding in which contemptor is not afforded notice or hearing in the usual sense of the word. That's the law. For actions to constitute direct contempt take place in the court, actions need to not necessarily occur in the immediate presence of the trial judge. Court is deemed present whenever constituent parts, courtroom, jury, whatever. But yeah, I mean, That's it. You can be held in contempt immediately, including attorneys. This happened to, I won't say a friend, but a colleague of mine, Adam Raposa. In this case, he freaking, I think, flicks off and then he makes a, I'm not sure to be gross in the pod, but a masturbatory gesture when the judge is talking or the DA is talking to the judge. It was called out. He was held in contempt. I don't know because it's not clear that he was detained right then, but he was held in contempt for 90 days later after the hearing. But you are allowed, as a judge, in the moment to hold people in contempt. That's the law. That's the law. I mean, you get mad if you want. So she's allowed to do this. Let's be absolutely freaking clear. That's the law. So any reporting otherwise is wrong, and you can hold in direct contempt. And if your attorney, for an attorney, and if the attorney wants out, you say a motion. I think you could orally say it, but the way that, I haven't looked into that part. But either way, you orally or not, you say, I'm requesting my PR bond. You get out, and then you get the notice and hearing if the judge wants to actually punish you by further contempt. That's it. Remember, at most, this lasts an hour. What's my opinion? So full stop. I think this was wrong. I don't think this was right. I think it was an overreaction, or it was a reaction to things that weren't in the proceedings. And clearly, there's animus between Miss Russell and Judge Gonzalez. That's why she recused herself immediately. I think it was abrupt. I don't think it was proper. I think that's why she let her out quick. I haven't talked to her. I don't know. And I think that's why she recused herself, because she don't do this again. I kind of don't know what else you want to ask of somebody if they do something they think might have stepped the line. That's it. But let's be clear. She's allowed to hold someone in direct contempt. That's the freaking law. Okay. So here's the statutes she's accused of having violated. All right. First is the felony, unlawful restraint. A person commits an offense if they intentionally knowingly restrains another person. It's affirmative defense that they're under 14, a relative, or sole intent was lawful control. It's a class C. It's normally class A misdemeanor. It's a state jail felony if they're under 17. It's a third-degree felony if the actor restrains an individual the actor knows is a public servant while the public servant is lawfully discharging an official duty or in retaliation or accounts of an exercise of official power or performance of official duty of a public servant. That's what they're going after. All right. So here's what they're hanging their hat on. They are saying that Judge Gonzalez, to bully Elizabeth, did that. I guess you can come to that conclusion. I think this is bullshit. I've represented in the thousands of criminal defendants, and I've gotten a number of them dismissals. I've had plenty of cases where I'm called in, and I've had people detained. I get called, or a detective gets called, and they let them go. A very close person to me was detained, read fucking Miranda after I told them I was already their lawyer, put in the back of a fucking cop car, and then the detective came out. These are like two goons, and the detective comes out, lets her out, comes to us, the attorney and the client, apologizes, and says, I don't think what the alleged conduct meets the offense. We're not proceeding with the charges. My apologies. For an hour, she was detained in handcuffs in a fucking cop car when she shouldn't have been. So let me ask everybody out there, should that cop be charged with unlawful restraint, a class A misdemeanor, because this person was on official duty? Yeah. Or should be charged with a felony because of official duty? Should they? I think that's a little rough. I don't know. So let me ask, do people think that every time a cop makes a mistake on an arrest, or we know they went too far, they need to be charged with unlawful restraint? Remember, it's a felony now if they're a public servant. A felony. Is that what we're going to do? Unless your answer is categorically yes, and we're going to tell every cop we're looking over the shoulder that hard. Look, I love it. Nobody distrusts police, DAs, the system more than me. But the system can't function if we're arbitrarily charging people with these kind of crimes because we don't like them. And I'll get to why I believe that in a second. I'm going to go one step further. The official oppression is just as bogus in my mind. A public servant commits an offense if they intentionally subject someone to mistreatment, arrest, detention, search, seizure, or a lien they know is unlawful. Intentionally proceeds. I don't buy this for a second. That's what happened. I just don't. I can't see it. She's allowed to hold someone in contempt. She perceived disrespect. When she kind of realized that probably wasn't it, she immediately let her out. She immediately recused herself. That's what we want to have happen. That's the point. Now, if you're telling me, Bo, okay, maybe not criminal charges, but Gonzalez should be held accountable. Maybe that's fair. But this should kind of make you a little get pause here, because this happened in Austin in 2022. And let's check this out. Guess what happened? This judge who did it to two attorneys, she got a public reprimand. She detained two different attorneys. Commission for Discipline gave her a public reprimand, and that's it. She didn't lose her license. She didn't get suspended for practicing. She didn't get a felony. She got a public reprimand. Now, why was Judge Gonzalez treated different? I'll tell you why. Because the commission thought they had to. So here's the rules. Rule 10 for candidates for judge and judicial officers. Here we go. On indictment or charge, a judge's indictment or charge with a felony or official misconduct misdemeanor, the commission must immediately suspend a judge from office with or without pay, file the complaint against the judge for misconduct stemming from the offense. They had to. The judge is entitled to a hearing. I don't know if she's doing that. I haven't checked those records. I know who her attorneys are. They're fantastic, by the way. And by the way, one of the reasons I feel very confident and kind of exclaiming the way I feel about Judge Gonzalez is her criminal attorneys are Mark Stevens. Her criminal attorney is Mark Stevens, who's not just the best criminal defense attorney I've ever met or know. He's one of the nicest human beings I've ever met. They don't get better than that. And her attorney for the stuff with the bar is Deanna Whitley, who's just sincerely one of my favorite people I've ever met at the courthouse. And I don't know, I'm going to trust their word. So you can't tell me that the people who decided to charge her and the cops didn't know this. They knew that the commission felt like their hands were tied. Now, could they have done less? Yes, probably. I don't know their inner workings, but I will say indicted for that puts them in a position where they do have to act. And I don't know that there. So I haven't gone full on whether or not they've overreacted or not, but I know they had to at least suspend and file the complaint. And I think they knew that when they filed the charges. And I think these charges are trumped up at best. So there. So if you think she should be disciplined, maybe she should. Bring up an official complaint and go. Now, a couple things to be clear. I have no problem with Elizabeth Russell. I wasn't one of the detained. I wasn't there. She can request a criminal investigation all she wants. She's within her rights. She's done nothing wrong. I have no problem with her. I wasn't there for the hearing, so I don't know. Judge Gonzalez is an overly, amazingly qualified judicial candidate. She's been a judge for 8 years. She's very well qualified. Now, she's had some controversy in the news. She had a gun and a personal luggage bag at the airport that I think had one in the chamber. She paid a civil fine. People got mad because she didn't get more punishment. Well, that's not her. That's the DA. That was the DA's call. So you can get mad if you want. Get mad at your DA for that. All right. The other controversy she had was she had the pride flag in her courtroom. Does anybody know what happened with that? She won the case. The commission said she can keep the flag up, but she took it down anyway. You get mad at her, but guess what? She won. She was within her lawful rights. And then she took it down anyway. So here's my issue with what's going on. Number one, people are celebrating and it pisses me off. We're all attorneys in this little community. Judges are attorneys. And when the commission comes after us, when we're dealing with discipline or we're dealing with criminal charges, the idea that you would celebrate a colleague is gross to me. And I think we should be better. We should be better than that because it could happen to anybody. And if you think you're above it, I hope it doesn't happen to you. And I mean that. Even though I'm mad at you for celebrating, I hope it doesn't happen to you. And I'm not going to be the guy celebrating, but there will be a part of me that says, kind of told you so. Harm is a bitch. Don't be that person. Number two, judges have the right to hold in contempt. Now, again, if you think she overstepped, there's a method. There can be appealed, there can be a lawsuit, and there can be judicial discipline. And for me, that's where at the best it should have stopped, if it even got that far. We don't use the cops and criminal charges to coerce judges off the bench we don't like. That's scary. Now, if you don't like the pride flag, and if you don't like the gun charge, if you don't like her demeanor, you don't like her conduct, guess what? She reapplies for a job every 4 years. Our Bexar County turnout something like 30% for elections. Our voter turns like 30% in the midterm elections. That's pathetic. So kind of, I don't want to hear from you if you're not actively campaigning. That's your way to get rid of her if you want to get rid of her. I support her. That's my opinion. And if you don't like her, okay. That's what elections are for. But are you really championing the idea that we're going to have police every time a judge gets contempt wrong, throwing him in jail, removing him from the bench because they overreacted? You don't want the pressure of that job. I promise you don't know what you're talking about. So I'm pretty harsh here. It really upsets me. I think we should be very cautious before we're celebrating anybody's troubles, and we should be very cautious before we're excited at the idea of police monitoring judges there. If I'm a judge now, I'm looking over my shoulder. You know, you may need a courtroom one day. You may need a criminal courtroom one day. You may need a civil one. And you may not want the other side disrupting behavior. You may not want disruptive behavior in the courtroom. You may need the other side to be held in check. And now our judges are just a little bit less likely because now the judge may think they're scared to hold someone in contempt. Because what if they're not popular? What if they're gay? What if they have a pride flag? Or what if they made a mistake with the gun in the past and someone doesn't like them? Now we're going to go after them. That's my problem. So that's my opinion. That's where I'm at. Feel free to disagree, comment, whatever. But again, I'm supporting Judge Gonzalez. I want these charges dropped. I want her reinstated with the charges dropped. And I want her to have a free and fair election. And then I want the people who don't like her to do what they're supposed to do and go vote. And then people like me who do are going to vote for her. So that's where I'm at. And to be clear, I have nothing against Judge Miss Elizabeth Russell. She's wonderful. She's been nothing but a friend to me. I have no problem with anything she's done here. I wasn't there, so I don't know what disrespect or was or wasn't happening. But what I will say is I'm not okay with her being detained, and I'm perfectly fine with her seeking her available remedies. But just because I'm okay with that doesn't mean I'm okay with what the police charge to do. Elizabeth's supposed to be mad. She's supposed to go after and do what she wants. It's supposed to be up to the discretion of the DAs to say, you know what, we don't charge judges for exercising their authority, even if we think they did it wrong, when there's discipline and there's appeals. It's the wrong way to do it. Thank you for tuning in. Appreciate it. See you next week. To see Justin Reyna, chiropractor, doctor of chiropractic, back on the podcast. He was on, and we talked about peptides, what they are, how to get them, their benefits, and how to use them. Thank you. Stay strong, and go Tigers.